The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
All right, Ripple scored a partial win in its 3-year court battle with the SEC, bringing a little bit of regulatory clarity for the crypto sector. A judge ruled that the sale of XRP tokens on exchanges and through algorithms did not constitute as investment contracts. However, the institutional sale of the tokens did violate federal securities laws. Joining us now is our legal panel, Willkie, Farr, and Gallagher LLP counsel Michael Selig, along with Alex Damsker, a former SEC attorney who's now an advisor to INX. Welcome to the show, Michael and Alex.
Good to be here.
What got us to this partial judgment yesterday?
So generally speaking, Ripple had a few issues from the get-go, which honestly were issues that happened to quite a lot of companies that were started at the same time. They offered sales directly and to accredited investors, institutional investors, and to the public. And a number of the sales that were done to the public, some of them were done. My understanding of this was that it was done directly, but the ones that were addressed by the court were the ones that were done through exchanges, through crypto exchanges. And some of the XRP was offered to employees as compensation, and there were other methods that they were offered. And the SEC, in due time, has come through and said, okay, XRP, you've offered all of these tokens. We think that these are unregistered securities. We think that you've been trading unregistered securities, and that's a problem. And one of the things we don't talk about is one of the things that the SEC could do is something called rescission, which is essentially when you have an unregistered security, they could say that basically all the securities now are mixed together because they're fundamentally fungible. They should all be retracted and tossed aside. And that's basically like a reverse IPO. And most companies don't survive it. Instead, what the SEC has mostly been doing is saying, look, you have unregistered securities. We understand that you're currently operational for the ones that are operational. If you also did not do something else illegal, usually what they're doing is settling and there's a fine. And that's why this has been not actually the SEC trying to crush an industry. This is really trying to shut down unregistered securities. And then the concept has been if we let unregistered securities continue throughout our system, the problem will be that most people will just go ahead and offer unregistered securities, and there will be nothing to stop people from continuing to offer them, just saying later on, well, we did that, but now we're operational, so let it just slide. So where we are now is after settling. After many different settlement attempts that didn't work out, this has gone through court, and both sides put forth summary judgment offerings, saying the other side essentially had no argument. Even if all of the facts that were in the complaints were true and all of the responses were true, then they still did not meet their basic elements, and the court basically said for each side, sort of yes and sort of no. And there are still matters of fact at issue here, which means it will still go to trial.
Michael, talk to us about if this is a win or a lose for Ripple. It doesn't seem like a clear-cut win. It seems like there's still a lot to figure out here. And, reading all of the information that comes out, it's hard to determine whether this is actually good or introduces more complications.
Yeah, so the judge here makes an important distinction between the investment contract, the security, and the crypto asset itself, the subject of that security in certain contexts. And so, in the seminal 1946 Supreme Court opinion, the Howey case, there was this idea that you had an investment contract because orange groves were sold to investors together with this land management contract. And so the combination of these facts and circumstances create what's called an investment contract. But the orange groves themselves are not a security, and so they can be resold and sold in different manners. And those transactions themselves just involve the sale of orange groves. And similarly here, the court says, look, we're not going to agree with this broad SEC interpretation that the crypto asset somehow embodies that investment contract, such that when it's sold in every context, it's always a security. The security is the investment contract, and the investment contract analysis under the Howey test is a facts and circumstances based test. And so in every context, you're going to be looking at all the different circumstances and facts that surround that sale. And so when Ripple went out and sold crypto assets, XRP, to institutional investors and made certain promises and commitments and gave a contract to those investors and said, we're going to do certain things. You're going to lock up your tokens in certain contexts, not in every case. And there were other sorts of rights and promises made in that contract. These institutional investors had a belief that they were investing money in a common enterprise with Ripple and expected profits based on the efforts of the Ripple team. When Ripple and Garlinghouse and Larson went out and sold tokens blindly on certain exchanges, and those sales were only around 1% of all sales on the exchanges, customers or purchasers of those tokens had no expectation that Ripple would go out and engage in any certain efforts. They might have not even seen any of the marketing materials or promises or white papers and things given to institutional investors. The court here actually reasons that these retail investors very much likely were just purchasing these to speculate on the investment potential of an increase in price. They're not necessarily looking to any sort of efforts of the Ripple team, and they don't know who's selling them the tokens. They'd not agreed to lock up the tokens or any other sort of contractual commitments. And so in that context, the court very elegantly distinguishes between sales where purchasers are really buying a commodity, a good, and those sales where there's more promises and commitments made, there's more of an understanding that there's a common enterprise with Ripple. Persons are giving funds directly to Ripple and understand those funds are going to Ripple to build an enterprise, as opposed to sales where people are really just buying a good, and maybe they'll go up in price, maybe not. And so that's a really elegant way to thread the needle here and create a world where we have certain assets that are not securities, but in and of themselves, they can be deemed to be securities because, for example, they could be stock or they could be notes, or they, in theory, could be investment contracts if all the elements are satisfied. But they're not necessarily investment contracts simply because they were sold as investments.
Yeah, doesn't it by doing it this way, threading the needle this way, as you put it, doesn't that essentially open it up to this? One can argue, the SEC can argue, well, yes, the general public didn't know that it was being sold as a security potentially to institutions. And again, Ripple's saying that it wasn't a security when they sold to institutions, but that's aside. But if the judge is going to say that it was, then the demand for XRP by being observed by the general public, seeing it go up, it would have induced them to go out and speculate on the asset. And therefore, it might not have been a direct sale of a security, but an indirect, if you will, by creating that extra demand, if you will, for XRP and sort of pumping up the price. Wouldn't that be the SEC's counter argument ultimately? And so that this judgment, this ruling, isn't necessarily to Ripple's benefit in the long term until they can absolutely say no sales were securities.
So the efforts of Ripple have to be those essential managerial efforts that people are purchasing in reliance upon. And without any relationship with Ripple or understanding that Ripple's going to go engage in efforts to drive the price, these are really just widgets or goods sold into a decentralized market. And the purchasers of those might be looking to all number of factors to increase the price, just like the purchaser of gold or sugar or wheat is looking to a decentralized market. Just because OPEC can increase the price of oil doesn't mean that they're looking to OPEC when they buy oil. And in the same way, Ripple might be a factor, but there's no contractual obligations. There's no understanding that the funds are going directly to Ripple to increase the price.
Alex, it doesn't seem like you agree.
That's actually not how that works. So there isn't a requirement for an understanding that this is a security or the managerial efforts are to increase the market price. The efforts have to actually be to increase the value of the company. And there is an understanding that there's a project team. Everybody has known for a long time. It's been common knowledge. There's a project team behind Ripple that is doing something, right? Press releases are being issued to drive value into Ripple. And that is the thing that fundamentally will drive market price. That's how all securities work. So fundamentally, it's not about whether or not their money goes to Ripple. That's not the test of whether or not it's a security. There is a test about things being a security because you're using them for capital raising, which is one of the things that happened here. The issue of whether or not the public, like what the public relied on, most of that isn't even covered in this opinion, right? Which is one of the reasons why it's actually ripe for appeal. But one of the things that they talk about is that, first, the concept that the investment has to be based on specific efforts to price just isn't how that happens. It really just has to be based on the efforts to grow the company. And I think there's been a constant understanding that here's the team, right? White papers are full of here's the team. Brad Garlinghouse and Larson have put themselves out as the people who are running this, and they're doing all this value. Here are the press releases. Look at what we're doing in order to increase the value of XRP. When you invest in it, you're investing with the hope of return. These are not people who are buying these tokens with the hope of using the tokens. That would be the distinction. Are you buying the tokens in order to transactionally use XRP? That's not what's happening. They're buying the tokens with the hope of selling them later for a greater value. That's the difference. So there's a few problems in this ruling that make it subject to appeal. I do think that, it's an interesting way to try and draw a distinction because clearly the judge is trying to make sure that the people who are current holders of XRP are not harmed by whatever is happening with their prior holdings. The problem is once you say that there's anyone that is holding a security, now you have this pool of securities that are mixed together with non-securities, and you can't tell which is which. And now we have a fundamental problem because we don't know if secondary buyers are purchasing ones that are securities or non-securities.
All right, let's switch gears here. Bail for former Celsius CEO Alex Mashinsky has been set at $40 million. That news came out this morning. He was arrested on fraud charges. Michael, what's your reaction to Mashinsky being arrested in this?
The allegations related to Celsius and the ongoing saga with Celsius, it's interesting in that many, if you talk to many investors in the crypto community, understood that this was potentially a Ponzi scheme or some type of fraud. He had very few major U.S. venture capital investors that you would see commonly investing in crypto projects such as A16Z or Paradigm or any of the household names. And so there was some red flags all along. But really, so many people lost money. I mean, I think there was over $1 billion that was not, accounted for when they filed for bankruptcy. And so it's not a surprising turn of events to see the arrest. It's a little late. We would have liked to see the SEC and CFTC and DOJ and others move before the bankruptcy even happened. But it's better late than never.
Alex, what's your reaction to this, to the timing? The company has gone through bankruptcy proceedings. To see this happen now, what's your take? What do you think's going on?
Could not agree more. Why did they wait so long? This would have been really nice before the bankruptcy. Who knows where the assets are now? And this complaint would have actually helped if the token holders wanted to file a direct or derivative action. Most of the assets already for Celsius have been distributed through the bankruptcy. So we're talking now about personal holdings of Mashinsky. I think, I agree with this concept that he just discussed about, there's a difference. Alex came from telecom. And it's very interesting if you move into this sort of finance, what he moved into was supposed to be banking. And originally that was actually banking. And so I think that's a very regulated area. And he had no experience. And so what I think is very interesting is that he was funded at all. And I think I'd want to talk a lot to the people who were funding him, but also where is the information about KeyFi and the people who are managing the money that I do not believe were actually registered money managers of any sort. So these were just some random people that were managing, hundreds of millions to billions of dollars.
Yeah, I think, Michael, to your point, the reason why those big funders weren't there with Mashinsky is they were busy giving money to FTX.
I was going to say, I think there's a lot of questions here for a lot of different people. All right, we're going to have to leave it there. Thank you both for joining us for this discussion this morning.
Thank you.
Thank you.
That was Michael Selig and Alex Damsker.